Hi there.
I seem to have a problem. I brought this from you recently and it doesn't seem to be working. I demand a refund under the Consumer Guarantees Act.
Well, how do I know the Consumer Guarantees Act applies to you?
Well, the Consumer Guarantees Act applies to both consumers and suppliers, including both individuals and businesses that either produce goods or services within New
Who's
Zealand.
the consumer?
Well, according to the Consumer Guarantees Act 1993, under Section 2 it states, a consumer is a party which includes both people and businesses whom acquire from a supplier goods or services of a kind ordinarily acquired for personal, domestic, or household use or consumption. So therefore, that's me, buddy. What's important here is that you, the supplier, need to be in trade. So if I bought products or services privately, or from someone who's selling something one-off, then I wouldn't be a consumer, and hence not covered by the Consumer Guarantees Act. However, this purchase I made for your calculator is covered by it, and I still demand my refund.
Since you know so much about the Consumer Guarantees Act, what guarantees are given to the consumers?
Wow, let me just call on my lawyer real quick. Yo mate, get down here.
So under CGA section 5 to 15, when it comes to supply of goods, CGA guarantees that the goods have to be of acceptable quality, which includes fit for all the purposes for which goods and types are commonly supplied, acceptable in appearance and finish, free from minor defects, safe and durable. However, it is not a breach of accepted quality if the consumers are told of defects before the goods supplied. A reasonable consumer would not use goods in the way that's inappropriate or excessive. B, the good has to be fitness for particular purposes and has to be comply with description, comply with sample or demonstration model. There's repairs and spare parts that are available to get offered, and then a manufacturer has to be honour the express guarantees. So under section 41, which is part 5 of CGA, when business as a consumer, CGA does not apply if the goods and services are resupplied in trade or consumed in the course of production or manufacture, or used to repair other goods or fixtures on land. It also guarantees two services. Under section 28 to 40, the guarantee gives for service the persons have reasonable care and skill. There's fitness for a particular purpose. There has to be a reasonable time of completion, and the price has to be reasonable.
Well, since you're so unsatisfied with this good, what rights do you have?
So my client has the right to claim for the remedies. They can return the goods to you to fix it. If it's not fixable, my client can ask for a refund, a replacement or refund. The replacement is still covered under CGA. However, you can decide to either fix it, replace it, or refund it at the first place. Similar, if the good cannot be fixed or failure is of substantial character, then the consumer may reject the good and ask for a replacement or refund, which including if the product is unsafe or it does not match the description in significant ways. Under Part 3 and section 25 to 27, for consumers that receive goods from manufacturers, they have the right to repair or replace the faulty goods. For other remedies that the claim, the damages are also applied. If consumers were suffered from consequential loss, which must be reasonably foreseeable, then the consumer have the right to ask suppliers or manufacturers for damage. Under sections 35 to 40, for the consumers that receive a service that do not meet one of the guarantees, they have the right to for repair, a compensation or refund based on whether the problem is minor or serious. Also, delays in returning the goods or appealing the service within a reasonable time frame may result in the loss of any rights the consumer has.
So how can I get out of the contract?
Well, under Part 5, Section 43, it is possible to contract out of the CGA if the following conditions apply to the circumstances. Firstly, both parties have to be in trade, which means only business-to-business transactions can be contracted out. Secondly, both parties agree to contract out and is then stated in writing and signed by both parties. Lastly, the terms have to be fair and reasonable for all parties involved.
So, as a business, what are your practical consequences?
Well, following the CGA is crucial for businesses to ensure that they are not breaching the law. Breaching the CGA can lead to serious consequences for my business, such as paying hefty fines, damages, and criminal offences. Obeying the CGA can help improve my customer relations and enhance my reputation, effectively assess and manage risks, avoid the costs of legal proceedings, increasing my staff awareness about fair trading laws. As a small to medium-sized business, it is important to train my staff to a degree to have a thorough understanding of the CGA. Operating everyday business according to CGA and trying not to attempt to contract out of the CGA is under Section 43. Furthermore, if I offer an extended warranty to my customers, they have the right to opt out within 5 working days according to the Consumer Guarantees Act.
For For more information, visit www.legislation.govt.nz.